Thanks everyone. Good morning and welcome to what I think is a very exciting panel and this particular conference. We will be addressing civil enforcement of cruelty codes, which is a novel idea that actually has a lot of potential. We've had some experience, as our two panelists will explain, but I think there's a ton of potential for many other states. And I think it's a great area too because it's cross-purpose. Nobody likes an animal abuser, and yet they're everywhere. And because of this great abundance, the criminal system really just can't keep up. Prosecutors have many crimes they need to prosecute, and even if this was all they wanted to do, they can't. They don't have that luxury. And so adding another tool to our toolbox, civil enforcement, is such a brilliant idea. And also the criminal justice system really focuses on the offender and has a higher burden of proof. It focuses on just punishing the person, whereas civil enforcement can help us focus on the animal, and let's just get him out of that situation. So our two esteemed panelists today will address the issues from both sides. First up will be Scott Heiser. He comes here from Portland, Oregon. The Animal Legal Defense Fund is quite fortunate to have him serve as our director of the Criminal Justice Program. Scott and his team work very closely with law enforcement officers and prosecuting attorneys across the nation to provide them the training and the tools and the resources they need to effectively investigate and litigate animal cruelty crimes that come across their desks. They also provide a fair amount of advocacy, cultivating relationships with the Association of Prosecuting Attorneys and the National District Attorneys Association to ensure that we get the best possible outcomes when cruelty cases come up. And Scott is particularly well suited for his current position. He served as a prosecutor himself for 17 years before he joined the Animal Legal Defense Fund in 2007. The last 8 of these years, he was in an elected position as the district attorney in Benton County, Oregon. Scott Heiser also got his law degree in Oregon at Lewis and Clark Law School, where he currently also lectures as a member of the adjunct faculty. He has served as the president of the Oregon District Attorneys Association. He was a member of the Oregon Governor's Drug and Violent Crime Advisory Committee. And he's also served on the board of directors of the Heartland Humane Society in Corvallis, Oregon. Scott's secret is out. In 2011, he received the Diamond Collar Award from the Oregon Humane Society for his work on behalf of animals. He really is a superstar and will fill us all in on, the great things you can do to prosecute animal abusers and the reason why we also need the second tool, the civil enforcement. And after Scott introduces the problem, we will hear from Gavin Parsons. He's come here all the way from North Carolina. Gavin is a civil litigator who received his JD at the Wake Forest University. He's now a partner with the law firm of Troutman Sanders. There, he practices primarily complex civil litigation. And by complex, the list of areas he's worked in, I can't even begin to explain. He truly is a generalist and has worked in many areas, and now he has also worked in animal law as he partnered with the Animal Legal Defense Fund on a civil enforcement of a cruelty case. Gavin has been recognized as a rising star in business litigation for the last 4 years running. He's a member of the North Carolina Bar Association, the North Carolina Association of Defense Attorneys, and the Defense Research Institute. He's his firm's pro bono coordinator, which is how he came to have the relationship with Animal Legal Defense Fund. And his clients are as varied as his practice. He's represented national franchisors who are seeking to enforce termination of their franchisees, to enjoin trademark infringement, to collect royalties, and to defend against fraud and liability claims. He's represented local governments and law enforcement officers against complaints involving civil rights, land use, Fair Housing Act, improper criminal prosecution, and the use of force. And he's represented businesses and insurers in commercial insurance coverage disputes involving a wide variety of claims. But I really think it's fair to say that Gavin's favorite client must have been Ben the bear. Gavin represented Ben on a pro bono in a very important matter that really changed Ben's life, and I'll let him tell you about that. So please join me in giving a warm welcome to both Scott and Gavin, and Scott will be up first.
Wow, thank you so much, and thanks for coming back in. I'm surprised anybody decided to return, but here we are for a bit longer. I'm happy to be here, and I hope I don't get too far off this mic. Here we go. If you have questions afterwards, or if you want to email me and get a copy of this PowerPoint or talk to me about any of these points, there's my email address and my phone number. I'm the criminal guy, right? So let's see, here we go. They give me this project, and I'm starting to feel like this cat. Civil law. Let me think about this for a while. Injunctions. Oh, farm, right to farm. All right. I don't know why I love that so much, but I truly do. All right, so I am the criminal guy, but there is a fair amount of overlap between what happens in the criminal justice system and civil opportunities that present themselves. And legislatively is what we're going to focus on today. But before we get to that issue, I want to share with you a couple of things about the criminal justice system per se. Then we'll talk about the civil issues that crop up in the criminal system. And then we'll talk about private rights of action. And then we'll get to the 19A stuff and bend the bear through Gavin. There are some things in your materials. There are some regulations that govern prosecutor conduct. And I'm not talking about the rules of professional conduct per se in your state, but I'm talking about the ABA guidelines, the NDAA's guidelines. And then there's some quotes from a couple of cases that give you a feel for how the bench views the prosecutors as carrying a heavier load, a higher ethical standard than any other lawyer in the system. And it's important for people to be mindful of that fact when they're thinking about why the DA isn't doing something they want them to do. And then if you really want to get into the detail, read the Dix case, which is in your materials as well. That's a California case, and that talks in some detail about who's in charge of the show. And I'm going to give you, I'll talk a bit more about Dix as well. And then we're going to walk through a couple of statutes in Arizona, Florida, South Carolina, and the like that have some opportunities that aren't specific to animal cruelty per se, but they could easily apply in animal cruelty cases. So first, remember that song from that hair band in the 80s, Every Rose Has Its Thorn, right? So every moth has its flame was where I was going with that. Didn't really work though. So as a civil litigator, I can see the temptation to sit down and go, God, there's so much suffering and cruelty in our system, and yet here's this beautiful statute. This is California's Penal Code 597B. Every person who subjects any animal to needless suffering or inflicts unnecessary cruelty upon an animal, or in any manner abuses the animal, or fails to provide food, water, shelter, all that stuff, commits a criminal act. That sounds pretty damn good, right? Well, guess what? Needless suffering has been construed to mean, well, we need to make some of these animals suffer because it's cheaper. Unnecessary cruelty, same deal. It is necessary to keep the costs down because we're feeding the millions of Americans that need to eat meat. Not to mention that when you look at a penal statute and then you try to apply it in a civil context, or if you try to apply it aggressively in a criminal context, did that just get louder? Thanks. If you try to apply it in a criminal context, you've got this rule of strict construction. A statute will be construed against the state and in favor of the defendant whenever there's an ambiguity. And that's true here, even in California, notwithstanding another section, Cal Penal Code Section 4 says that rule of strict construction isn't supposed to apply, and yet the case law has developed and says, well, yeah, but it kind of sort of still does when you get into vagueness and due process issues, constitutional issues crop up through there. So, and then you've got 599C that talks about all of the additional exemptions that apply in California. So it is a tough road to hoe to say, hey, we've got institutionalized cruelty on a factory farm. Let's just take the criminal code and let's apply it. A very tough road to hoe. And in fact, it's a hostile work environment, to be sure. All right? Now, people who think that the criminal system is a great place often think, well, we got juries, and so they're the voice of our community. But when you get into the trenches, you sometimes, especially if you get unlucky in jury instruction, say you miss Rich's talk this afternoon, don't miss Rich this afternoon, you might end up with one of these juries. And it's happened to me. I've had jurors fall asleep on me. I've had judges fall asleep on me. That's because I'm so charismatic, I'm sure. But it's seductive, right? Because you've got really good penalties. This is a case Diane Balkin worked on in Colorado where a guy poisoned his neighbor's dogs and he got 9 years for it. That's a pretty feel-good moment for people who are looking for accountability for those who offend animals or abuse animals. In West Virginia, this is another case we worked on. Jeff Nally, free to a good home. He was getting puppies and torturing them, and he got 10 to 45 years. Really good sentencing in the right circumstances. But there's a frustrating aspect of the civil law that I think probably drives civil litigators to the cruelty code more than anything else, and that is, say it with me, standing, right? So don't you get farmers standing in a field? Come on, that was awesome. All right, so Article 3 in prudential standing, it causes many a law student to want to contemplate leaving law school or worse. So yes, the criminal justice system from the outside might look like a sleek, sexy black Maserati ready to go, when in fact, okay, I'm not kidding. I mean, it's a flip comment or a flip way to say it, but it's true. The criminal justice system truly is broken, truly broken, and it's trying to fix itself, and here's the proof: drug courts. Drug courts are a model where offenders will waive all of their due process rights, forget the gamesmanship of trying to walk and game the system and get away with something, admit they need help, and get plugged into treatment by waiving their due process rights. Judges, defense lawyers, prosecutors, parole and probation all get involved in this, and it's working. So there is some hope. But in the meantime, we continue to convict innocent people in our criminal justice system at an alarming rate. We continue to acquit guilty people in highly public trials, which are eroding the confidence in our system. We base one of the fundamental tenets of our procedural rules on a rule of exclusion, right? The exclusionary rule requires relevant evidence to be knocked out of the record because we're going to penalize law enforcement until they get the Fourth Amendment right, when our appellate courts disagree about what the Fourth Amendment is and how it applies in a given fact pattern. And they have months to think about it, and cops have seconds to think about it. Y'all think that there's reciprocal discovery in the civil world, right? Well, generally there is, but in the criminal system, as a practical matter, there is not in most jurisdictions. For example, in Oregon, a few years back when I was DA, I had a cruelty case, domestic violence case coming up for trial, and it was a complex case. It was going to be a 2-week trial, serious physical injuries to the victim. And we got our witness list from the defense. The case had been set for trial for months, and we got our witness list from the defense, 15 witnesses, 3 days before trial, and the trial judge wouldn't give us a continuance. And that's a known fact. It's a game that the defense bar plays, and they get away with it. Our evidence code, we think that we trust the jury with the facts, when in fact our evidence code says, no, we don't really trust the jury with all of the facts because we exclude a lot of prior bad conduct unless we can qualify specific exemptions under Rule 404. And then I could do a whole talk on truth in sentencing, but I won't. What you see in the media, what you see right there, Jeff Nally, 10 to 45 years, or the guy from Colorado, 9 years, immediately take 20% off of that for good time. And then you start talking about earned time credits and early release provisions and other systems that are in place to reduce the corrections budget and save money on prisons, and you're talking sometimes as much as a 40% reduction. So, aside from being phenomenal entertainers, what do these three guys have in common? Civil cases. Michael Jackson settled a civil case for an undisclosed sum. Mr. Beretta settled a killing his wife case for $30 million in civil court. OJ, after being acquitted, and Blake was acquitted too in the criminal system. OJ, of course, you all know about that one, 33.5. So the civil system works better, in my humble opinion. All right? So there's also this notion that we could force DAs to play with us better, right? If we could only make the DA do what we want to do. This is a quote from the California Attorney General in a case that we handled with the, is Jill here, Jill Telfer? Jill? No, okay. In Nevada, California, involving a rescue that was trying to get the court's ear to address a restitution issue in an animal cruelty case on the restitution side, and initially got intervener status to actually file pleadings and argue to the court. And the AG came in and supported the DA opposing that and said this, quote, "The prosecuting attorney possesses the sole discretion to decide what charges to file and what punishment to seek." Okay, well, that's fair. The case has already been charged and punishment's been sought. We're at sentencing, but there's more. Not only that, and she's quoting from Dix here, the prosecuting attorney also has the sole discretion over the conduct of the proceedings once commenced, including the responsibility to decide in the public interest whether to seek, oppose, accept, or challenge judicial actions and rulings, okay? The DA is in charge here, folks, and we don't have a lot of authority over them except at the ballot box, at least in California, and this is generally true in most states because of the separation of powers doctrine. So the system is broken, but there are opportunities nonetheless on the civil side of things. So what civil legislative opportunities do the failures of the criminal justice system present to us? And there are several. First off, hey, there are these states that have mandatory arrest statutes on the books, right? That's the list. You are required as a police officer in Nebraska or in Oregon to actively investigate and tender for prosecution animal fighting cases in Nebraska and animal cruelty cases in Oregon. Same is true for Michigan, Maryland, these states. So as a civil litigator, if a police officer isn't doing this, what's your opportunity here? Non-discretionary duty, mandamus, right? Okay? So citizens can file, they have standing to challenge mandatory duty of a police officer or a public official to do their statutorily mandated duty. And there's good case law out there, especially in Oregon, that says no money is no excuse. We've got a case in Oregon where the sheriff said, I'm not going to serve civil paper anymore because we don't have any money, we got decimated in the budget cut, and I'm not going to serve process. And the statute reads just like the animal cruelty mandatory arrest statute and says you shall serve civil process, defended on a theory that I can't pay, couldn't afford to pay, and he lost it. So animals as victims. Now that analysis breaks into two tracks, right? Two tracks. What are they? The first track is animals who are owned by innocent third parties that are victimized by like the next door neighbor or the angry ex-boyfriend, that kind of thing. Or animals who are victimized by their owners. So as to animals who are owned by the offender, follow and enact a statute akin to what we've got in Rhode Island here. This is relatively new, that the court has the authority to appoint a veterinarian to recommend and make advice to the court about the well-being and the best interest of the animal when an animal's issues are at stake in any court, civil or criminal. Vermont tried to pass a statute akin to this just recently, unsuccessfully, but this is a big one. This is a big one. It's sort of akin to what happens in child abuse cases and the appointing of CASA as a court-appointed advocate, but you need specific statutory approval to do it. And then what about the situation where you've got the third party, innocent third party who owns the animals? This is a civil compromise case, again, out of Oregon. And for those of you who don't know, civil compromise is a way for a defendant to basically buy their way out of a criminal case. They go to the victim, they throw money at him, and they get him to sign a release, okay? And we've got a case going right now in Oregon where the defendant shot some cows that were on his property and realized shortly thereafter, oh, geez, that's a crime because you can't use deadly force to defend your property against cows who are chewing up your grass. And went running to the rancher that owns the cows and wrote him a check for like $45,000. And he, of course, got the contract that waives criminal liability. The DA is objecting, and she's objecting on the theory that this case, in child sex abuse cases, stands for the proposition that even parents of children of sex abuse have a fiduciary duty to their children to make the best choices regarding their welfare. But when when money's being thrown at them to buy their way out of a criminal case for their kids, there's a conflict and a guardian needs to be appointed. So the DA is challenging the civil compromise in that cow shooting case on this theory, and that hearing's coming up in a couple weeks. So my point is, statutorily, what do you do here? You go out and you modify your civil compromise statutes that say animal cruelty cases aren't subject to civil compromise. Or if you can't get that far as a compromise or a fallback, you say, if you're going to do civil compromises in this context where the third party has a conflict of interest, then appoint a guardian. All right, so then here's the sort of the usual stuff. Some of you that have heard me or taken my class will know this stuff pretty well. Pre-conviction forfeiture. How do you get the animals out of the system while you're waiting 6 months, 9 months, 2 years for the criminal case to resolve? You've got pre-conviction forfeiture statutes that are civil in nature. Same for cost of care bonding and lien attachment and foreclosure proceedings. Those are all civil. A lot of states don't have these. A lot of states that do need improvement. There's a tremendous opportunity here as well. And then for the nut jobs. Right? We've all seen them. I'm harping on Oregon because I practice here and there, but the Primrose case out of Oregon is a classic example of this. It was not able to assist in her own defense criminal case, hoarding case involving cats. Case got dismissed because she couldn't stand trial, and left holding the bag with what are we going to do with these animals, and it didn't seem fair to just pursue the civil remedies against her because she was lacking competency. So the people caring for the cats filed a conservatorship, and the trial court ruled against it, but the Court of Appeals said, you know what, you can't actually use the probate code in this context. So the message here is, if you have ambiguity in your probate code, go ahead and amend it to make it clear that the court has the authority to appoint conservators or guardians in this context as well. 2 words about drafting legislation. One word, really. Legislative findings. That's 2 words. Legislative findings, okay? This is really important stuff. This is a bill or a statute that we helped get enacted a few years back, and I think it was you, was it not? Yeah. So this is our mandatory vet reporting statute in Oregon, and as a preamble to that, the legislature made a specific finding that there is a clear link between domestic violence, child abuse, and animal cruelty. And that has been worth its weight in gold. We cite that all the time, not just in the context of vet reporting issues, but anything that comes up with animal welfare, because it gives context to what's really driving the legislative choices here. This just got passed this last session in Oregon, just in July, signed by the governor in August, and Laura Dunn wrote it. Way to go, Laura. This is Senate Bill 6, and it says, this is in the code now in Oregon. Animals are sentient beings capable of experiencing pain, stress, and fear. Animals should be cared for in ways that minimize the pain, stress, and fear, yada, yada, yada. There are people in the committee hearings and we have a veterinarian who's old school who doesn't think the animals feel pain. And now, I know. But now it's in the freaking code, dude. Guess what? We win. Oh, I can't believe I just said that. All right, private rights of action, nuisance abatement. This is the coup de grace to my humble taste. This is the one. This is the silver bullet. And there are a number of states, not just North Carolina, which Gavin is going to talk about in some detail. This is the Cadillac version in North Carolina, and we'll hear about it from Gavin, how it works and how it's applied in practice. But there are some other states that apply it as well. But first, a lot of times when you apply a civil right of action in a criminal context, the defendant or the target of that correction will claim, hey, wait a minute, this feels a lot like criminal because you're incorporating the elements of a criminal statute into a cause of action against me in the civil context, therefore I want all of my due process rights, unanimous jury, proof beyond a reasonable doubt, blah, blah, blah. Well, guess what? Doesn't fly. The Court of Appeals in Oregon rejected that back in 1979. And most other jurisdictions have as well, although I think Canada might have gone the other way on it, but that's another topic for another day. And it's not unprecedented, right? This is already on the books federally. We've got a number of federal laws that give citizens private standing to challenge conduct under a federal statute, including a series of environmental statutes, and here they all are. They don't always work that well, as we learned from the last panel, but the point is, Congress has said citizens need to be able to enforce some of these statutes because we recognize the federal government's going to under-enforce. So here we go. And these are all these statutes are in your materials so you can peruse them at your leisure. But Arizona, these are not animal specific, but they're criminal specific. They say in essence that residential property that is regularly used in the commission of a crime is a nuisance, and a resident of a county or city who is affected by that nuisance may bring an action in Superior Court. Animal cruelty is a crime, right? So what's a nuisance? Animal cruelty, bring your private cause of action in Arizona. Florida, we got a case, and I think we probably have a few questions about this case for Jenny when we get to that phase of the conversation, but here's the statute in Florida, and it says that any citizen has standing to sue to abate a nuisance that's defined in 823.05. Here's 823.05, and it says, very broad terms, any place where any law of the state is violated shall be deemed guilty of maintaining a nuisance. The person who owns or occupies property where any law is being violated. So, hey, we got backyard slaughter. That's animal cruelty. It's unregulated slaughter. It's a lot of things. It's a violation of the law. Bam, we're going to sue you. And it hasn't worked out that well so far, but we're still fighting. South Carolina, same deal. South Carolina is a little more, I urge a little bit more caution here simply because of the continuous breach of the peace definition, right? It requires a continuous breach of the peace to be conducted or permitted or carried on, and a continuous breach of the peace means something that directly disturbs the public peace. I think this applies in hoarding cases, for sure, but probably not the discrete one-op kicking or beating of a dog or something like that. So here's Michigan. The conduct prohibited by Section 49. This is the dogfighting statute. So in Michigan, if you know about dogfighting, it's sort of a derivative of the anti-gang stuff. If you know about dogfighting, you can sue to abate it. And there's the statute that says any citizen can do it. I'm going to skip New Jersey. I'm going to dive into what happened in Oregon. So, I got pretty fired up about this theory a little while ago, and so with the help of Representatives Gelser and Witt, we got a bill dropped last session that amended our nuisance statute that currently applies to prostitution, drugs, gambling, and booze violations only, and tried to expand on that list by one and say prostitution, drugs, gambling, and liquor, and animal cruelty. That's all it did. And we got a hearing in House Ag, and we have a member of House Ag who used to be a state game officer who at one point prior to this event had boasted about how many sea lions he'd shot. It would have if you stacked them up, it would have filled the room. And he was horse trading with the committee chair and wouldn't let because of some other stuff that was happening with the budget, this bill never came up for a vote, though I know we had the votes to pass it out of committee. So we will try again next session. And hopefully he's not there, and if he is, then so be it. We'll work him. A couple of warnings. The right to farm laws. Every state has a right to farm statute. You gotta read those statutes, because if you go after a nuisance theory involving agriculture and you don't know what you're getting into on the defense side of things, you're going to be leaving yourself out to dry. So do your homework and check your right to farm law in the state where you try to employ one of these things. And then I guess another thing, be careful what you wish for. In Florida, we got the gestation crate ban passed, and then zip, zap, boom, regulatory taking, and now there's money going out the door because that farmer had invested a ton of fixtures and hardware into operating an intensive confinement facility, and he was compensated handsomely because of that regulatory taking. So that is my 20 minutes. I am going to turn it over to Gavin to talk with you about 19A, and then Jenny's probably going to jump up here and talk to you a bit more about what happened in Florida. So here's the Cadillac, or since we're here in Palo Alto, the Tesla version of the law. All right, Gavin, you're up.
First of all, thank you all for having me. I've come out here I'm from Raleigh, North Carolina. I practice with Troutman Sanders, and I am a generalist. That means pretty much whatever my dog trees. I'm with a large law firm. We handle all kinds of different matters. Oh, sorry. Used to shouting. I handle all kinds of different matters. This is my first animal law case, and this was a great collaboration. I want to thank in particular Matthew Liebman with ALDF. Our firm works with ALDF across the country, but this was my first opportunity to work with you, and this was a great experience. I played a small part as part of a larger team effort. We had ALDF members. I already mentioned Matthew. We had PETA, but Matthew Carter-Dillard with ALDF, Carnia Nasser and Martina Bernstein with PETA, Delcy Winders also with PETA, Federal Express, which you'll hear about later, and Callie Gerber, who is a local animal law attorney exclusively in Raleigh, North Carolina. Write that down. Callie Gerber, Gerber Animal Law Center in Raleigh, North Carolina. She is a wonderful animal lawyer, and I'm going to shamelessly plug her all day. So yes, write it down. This is one litigator's perspective. I said I'm a generalist. Litigators, if you ask them how to handle things, you will generally get, you ask 10 of them, you're going to get 10 different answers. So this is my perspective on 19A. Matthew, I see you sweating. I'm going to qualify that. This is my perspective on 19A and one way to handle it in North Carolina. There's several different approaches. So with that, let's get started. Okay. All right, 19A, it is very broad. It pretty much defines animals as just about every living thing. It's in the paper. What I direct your attention to, though, is cruelty. Cruelty is very, very broad. That's the key part of the statute here. It is cruelty or cruel treatment is unjustifiable physical pain, comma, suffering, or death is caused or permitted. So the suffering is what we keyed in on in this particular case. Suffering doesn't mean physical pain. If it were only physical pain, this would be a lot harder to apply, particularly in our case. Again, the definition of cruelty and cruel treatment, the term suffering is going to be the point of emphasis. Suffering is, in our case, was broad enough to include things that are not easily identifiable or demonstrable. It's not something psychological or mental suffering. You can't x-ray it. You can't generally show it on a photo. It's something that you got to show in other ways. So that was, frankly, key for us here. Plaintiffs, who can sue? Again, this goes with the whole broad theme. Anybody. You don't have to be a resident. You don't have to be in the county. You don't have to be a citizen. You don't have to be a resident. Animal welfare organizations, ALDF. ALDF has brought a number of these cases in North Carolina. Defendants, this is a key point from the beginning. It's anyone that owns the animal or has possession. What does this mean for litigators? Name everybody. And I mean name everybody, because in our case, there was some straw men involved who we got to the hearing to finally determine what was going to happen there, and the owner of the bear changed. We had done some discovery, and for $1, he tried to transfer the bear to someone else. It didn't turn out so well for him, but at any rate, on the front end, if you were suing someone for animal cruelty in North Carolina, name everybody. All right, you can get different types of relief. It's very broad. It's also very powerful. Preliminary injunction. You can get you can go in and immediately get temporary custody of the animal and expenses for its care and treatment. Also, final resolution, you can get a permanent injunction. The permanent injunction, it will terminate the ownership rights of the animal owner and possessor. You can take it away from them, yes. You can get the cost of care going forward. Again, this can be expensive, particularly if you were talking about a large or an exotic animal over a long period of time. Other areas, you can enjoin the defendant from ever acquiring these types of animals again, or you can get the judge to limit the conditions on which they can get these types of animals again. Or in our case, she decided he was never going to possess a bear again. So it's very broad. This has been the bear. This is 19A in action. On the left is his cage, and on the right is where he's at now at the pause facility. Ben's case. Ben exhibited stereotypic behavior, which basically meant that he paced incessantly. I had never seen anything like it. One of the issues for us is we didn't have classic documentary evidence of physical pain. There were some things around the edges, but it was going to be really hard there was no missing limbs, there was no real evidence of maiming, no wounds or sores or limping or something that would definitely indicate a musculoskeletal problem. So instead we had, again, this was sort of our challenge. Ben was kept in a 12 by 22 foot enclosure. You saw it's chain link fencing. It had a concrete pad, a tin roof. He had a water trough that was for drinking and bathing, and a very small enclosure for Ben to sleep in. The enclosure, I'll say, it was more open. There was no way for him to really seek privacy or get away from if there were people coming by taking a look at him and he was ready for a break. He really had no area to just go and sort of den in. Ben was fed dog food by basically dumping it on the concrete slab. You couldn't really get into Ben's enclosure, so they dumped it through the fence or they sprayed off the concrete pad every so often, but they didn't go in. Ben did not come out. There weren't any trees or any other real natural materials that a bear would have in a normal habitat. He'd been there at this facility for 6 years. He'd never been out of it, I don't believe. He had not been provided with veterinary care regularly while he was there, and basically sitting in this concrete area, he couldn't engage in any normal bear activities. Also, visitors came into fairly close contact with Ben. There was fencing, but they were able to throw him food or white bread or hot dog, whatever the children that came through were eating, they could throw it to him, and feeding the bear. They sold food, go and feed the bear whatever they had. So if there were diseases that could be passed from the humans, that was the opportunity was there. One of the key things about this case was experts. And that's another, I'll harp on about this later, but ALDF lined up 2 international bear experts before I ever got involved. It made my job much, much easier. Dr. Heather Bacon from the United Kingdom and Elsa Paulson from Canada were able to testify that based upon facts and investigation that was done early, again, before suit was ever filed, that Ben was he was actually suffering. There's conclusions, and their affidavits and their reports were pages. These were the types of expert reports that I would have used in a product liability case or drug and medical device case. It was the same approach. It was just with an animal. They were great. So I'm summarizing, but it was stereotypic pacing during 75% of his waking hours. He was biting, pawing, headbutting the chain link enclosure, and he was eating his own feces. They were able to say this is not natural for bears in the wild. They also concluded that he was likely experiencing physical pain, that they were not able to get in again and examine him because they had to walk through like a normal customer and just observe, but the pads on his feet were worn and pink from living on the concrete. They also opined that if the conditions weren't changed, he would likely experience greater harm. Let me back up and give you a little bit more information. This case was filed, and we conducted some basic discovery. That meant we tried to get documents from the defendants. Initially, they were represented by a lawyer. The lawyer later withdrew. So we were dealing with a pro se individual and a pro se company and some family members. They gave us some documents, but not a lot. We conducted some depositions. We found out, we basically tried to establish who owned the bear. Was it the company? Was it the individual? So we knew we had all the right people when we came before the judge to try to get a final hearing on this. We had our affidavits. They did not go and have an expert, a veterinarian, or anyone that really spoke up on their behalf that tried to explain what they were doing, and that didn't work out so well. We submitted these 2 affidavits from our 2 experts, and they were uncontested. And what happened in our case is we filed a motion for summary judgment, which we basically said there's no issues of fact. We submitted our expert affidavits and a brief. And again, I got a lot of help on the brief from folks at ALDF and folks at PETA. It was a very good brief. We submitted all this and then waited. We came in to see Judge Kimbrell Tucker, who is a district court judge in Cumberland County, and stood up, and I thought I was going to speak. It was our motion. And I introduced myself. I introduced Carney Ann Nasser, who was the PETA lawyer with me, and Callie Gerber, and she promptly told me to stop. I'd not had this happen much before, and then she looked at the defendant and started asking him some very pointed and very unhappy questions, and it went downhill from there. So this was at which point he said that the hearing couldn't go forward because he had transferred the bear to someone else for $1. It went downhill from there. At this point, she said, based upon the uncontested affidavits, that she was going to allow us to transfer Ben from Fayetteville, North Carolina, to the Paws Sanctuary in California, pending a final resolution of the case. And she asked me, she said, do you have a facility for this bear? And I said, yes, ma'am, but it's in California. She said, I don't care. Go ahead and send him. That's fine. So she was not very happy, and she based her decision on the facts, the expert affidavits, the just uncontroverted facts, and the scientific knowledge that they brought to bear on it, published research, those kinds of things. So she also ordered the defendants not to harm Ben. They were ordered to provide immediate access to us so that we could get him ready for his trip, and he was moved successfully to Paws August 9th and 10th of last year. Pretty soon after we got the preliminary injunction, I got a phone call from a colleague in Raleigh who they finally reached out and got counsel, and they wanted to talk about a way to try to resolve this case because we had the judge set it on for hearing 3 weeks later to grant a permanent injunction, most likely. And we ended up agreeing to the entry of a permanent injunction by consent with some specific terms in it. And the judge approved those terms on August 27, 2012. In the permanent injunction, some of the key portions of it, it completely terminated the defendant's interest in Ben. It prohibited them from ever owning another bear or keeping bears again at that facility. They may not seek additional licenses to ever obtain bears again. They could not use, they had a website where they were, this case had gotten some attention, and there was a National Geographic episode about it, and they were marketing their website, soliciting funds, build Ben a bigger enclosure. And they had actually raised some money based upon their website, and it was about $2,600. And the judge specifically ordered them to take that down and not use that as a way to try to solicit money in the future. The other part of that was she also required them to pay the $2,600 to Pause to help pay for Ben's care at Pause. And again, it was kind of surprising because when, again, we came in to announce the settlement to the judge, and she looked at me in the most direct manner possible, and she said, "I see this. Does it make him pay any money?" I said, "Yes, Your Honor, it does." And she said, "Good, because we weren't going to have a settlement today unless he paid some money." It prohibits the defendants from ever going out to Pause, harassing their employees, or having any other contact with them. It also, again, prohibited the defendants from soliciting any additional funds. Okay, that's the Ben the Bear case in a nutshell. There was a lot of specifics in terms of the back and forth and how it got there, but I think the important part for this is the takeaways. What did I learn? What I could tell you if you were wanting to do something like this, either in North Carolina or elsewhere where there is an animal statute. First of all, there was a great initial investigation. This was how I would have approached any other commercial or pharmaceutical case if I was trying to get something done and it was going to depend on science. You're going to need a scientist. You need an expert. You need a veterinarian or someone, if you have an exotic animal like a bear, go and get a bear expert. Have them help you out. The case will pretty much write itself. Animal abuse cases like this are pretty terrible on their own. You really, I mean, honestly, this is not, I don't want to say it's not that difficult because it is, but in our particular case, the facts themselves, we wrote a brief, we basically presented the judge with the facts, and she became unhappy. It wasn't there wasn't much eloquence or argument. It was just simply bundling it, getting it in front of the judge, and she really did the rest. Early retention of well-qualified experts who, I don't have this on the PowerPoint, but it's in the paper. You need to check your jurisdiction, check with your local council. North Carolina is now a Daubert state, so your expert, you need to be careful when you choose them. They need to be Daubert qualified. They need to be able to survive a Daubert challenge if the defendant has means to challenge it. So that means that they need to have, again, peer review research, and they can survive, their science is sound. So prepare that on the front end. Retain your experts, have them help you conduct the initial investigation, fact gathering. What will they need to be able to give you the opinions that you're going to be able to need to actually go in and seize an animal? Also, carefully consider who the parties will be. In our case, we had 2 local concerned citizens in Cumberland County. They actually, I believe, brought the case to ALDF's attention, but they were local. Whether you have local folks or, ALDF or another concerned group could have brought the case. Also consider the defendants. Like I said earlier, name everybody. If you think that they have ownership interest or you think that they may work with the animal, go ahead and name them all, because if you don't find out in discovery, you don't want to get to the hearing and find out that you haven't named the right damn person, because your injunctive relief is going to be really hard to maintain. Your approach to the case, again, it largely depends on the case, but what I would say would be understatement would be key. That means the facts will really speak for themselves. You don't need a lot of adjectives. You don't need a lot of rhetoric. You just need to kind of get it in front of them in a clear and concise fashion and make sure that they understand the science and that they get the science. I would keep it quiet. Again, I've already given you the lawyerly thing and said that, this is my approach to it. Well, this is my approach to it. In our case, we kept it very, very quiet. And we had a lot of conversations about whether or not to keep it quiet. But we did. And in North Carolina in particular, as a result of other cases, the Duke University lacrosse case, there was a criminal prosecution. There's some ethics, very specific ethics rules that have arisen out of that case. And judges and the state bar really don't like you talking about your case out of school. So there's some specific prohibitions in North Carolina. If you're interested, I'm happy to send you the opinions. But media exposure in certain types of cases can hurt your case. And in North Carolina, if it's your lawyer or if it's a party talking about it, it can hurt you. Obviously, it's venue specific. Again, you can violate the ethics rules. You can also anger your judges. If you have to talk to the media, just the facts, refer to pleadings for quotes and specific information, provide the media with copies of the pleadings. They usually really don't want to read them, so you're being helpful, that's good. And don't characterize. The reporters will always call you and want you to characterize what the other side has done. Don't do it, just refer to your pleadings. Be careful what you wish for. And honestly, you need to consider your goals and be careful what you wish for. North Carolina has a very broad and some would say very vague statute. So think about it from the outset if you were going to pursue an animal case in North Carolina. What is your goal? Do you want to free an animal? Do you want to free Ben? Or do you want to free a group of animals? Do you want to set a legal precedent? Is this something that is more important, or is this the main goal? Or are you trying to raise awareness or make some sort of political statement? These are all things that you really need to know going in on the front end, because it will dictate what you tell your lawyer to do or what your communications with your local counsel. Consider whether any of these goals conflict. Your goals can help guide, again, how you handle the case. Consider your venue. Again, if you're going to be in North Carolina, what's North Carolina like? What will the public reaction be? Is there a potential for backlash? Is there a potential for a political reaction? Consult folks in the venue. Either ask your lawyer or ask people in the area what may happen. Again, if you are a private practice lawyer sitting in the room, or you're a concerned citizen and you want to bring an action, what should you do? You need to bring in a partner like ALDF. Get an animal welfare organization. They have great expertise. Don't ask why, you just need them, okay? Just take my word for it, just call them. They have expertise in animal husbandry and the state and federal animal regulations that is absolutely invaluable. I could not have done this without help. They also can help you find experts and others who will help with the case. If you're an animal welfare organization, retain good local counsel. Don't ask, you just need them. They know the courts, they know the judges, they also know the local politics. Again, this is something that you need to know, particularly when you come to my state. As I put in the paper, in some counties, a Republican can be your best friend. In other counties in North Carolina, it might be a Democrat. It really, really varies. So get local counsel. It is a local issue, and trust them. I'd like to acknowledge the two plaintiffs, Colonel Hosea Ray and Ricky Harrison. I think I've mentioned ALDF and PETA. Callie Gerber, I am shamelessly plugging her. Callie Gerber, Animal Law Center, Raleigh, North Carolina. The folks at PAWS helped make this possible. Federal Express. Also, this is a video. This is Ben at his enclosure in California. I think this will send me over just briefly, but it's a...
I'll open the floor to questions, so I'll encourage you to come up to the microphones, and you do have to get fairly close to be heard. And it usually takes a little while to get people to come up. So I will also ask you, on your apps for this conference, there's a place for you to fill in who you are. If you can populate your data on the attendees, that would also help us, because one of the main goals of this conference is to allow us to all find each other. So if you've got cases like these, we can find yourself. So please fill in your attendees. information, and we've got our first question.
Yes, hi. What about attorney's fees provisions in the state statutes? I know that Scott mentioned several federal statutes, but I'm just wondering if this Section 19A in North Carolina or other state statutes have attorney's fees provisions.
Good question.
Yeah, we also have to get close.
That's a really good question, and I will have to get back to you on that because I don't know. All I did was cut and paste those clauses that show you who has the right of action. I think even if they don't have an attorney's fees clause, correct me on this, most of the time you can generate an attorney's fees liability if you offer a sweet settlement and then you beat it at trial if they don't take it. So I think by default, you can generally position yourself to get attorney's fees most of the time.
North Carolina, I would say it is a murky issue. Our definition of cost is ever shifting. 19A does not specifically provide for attorney's fees. So if you are seeking, you can get costs, but those are costs like deposition expenses for court reporters and things like that. It's a murky area.
So congratulations, I'm glad you settled. Was it your intention to put this in front of a jury? And can you talk a little bit about making that, jury trial, court trial distinction when you're getting ready for a case?
For Ben the Bear, it's judge only. 19A is a bench trial. So that is one of the wonderful and scary things about it because it really is going to be determined by a judge. You don't know in North Carolina who you're going to get. So one day it could be Judge Kimbrell Tucker. The next day it could be someone else. So you really don't know.
And on that really gives me a great opening to talk about our work in Florida that Scott had alluded to, where Ben the Bear is the awesome Cadillac 19A. North Carolina, we love them. In Florida, we're just using the normal nuisance code to suggest that, hey, backyard slaughter violates a ton of laws. Cruelty, selling uninspected meat, selling horse meat. All of these horrible things are going on in Florida, which we found out again through an investigation. We thought we had a pretty simple nuisance case. Don't need standing, any person can bring it. We filed this case in the Hillsborough in the 4th District of Florida, and we faced a motion to dismiss. That's pretty normal. It was actually a very laughable motion to dismiss, didn't really address our claims at all, talked about the 8th Amendment and human suffering and the other defendant's farm and all sorts of bizarre things. So we went into this motion to dismiss jazzed. We had the media ready to talk about backyard slaughter again. We're like, surely we're going to win. And we were dismissed. And it was unbelievable, but it's again because of the judge. The judge really just didn't want to hear anything about cruelty in his court. He said, this is a civil court. Why does your complaint list criminal allegations? And he didn't even give us the courtesy of dismissing with prejudice, so we've had to take out some of those references and we're just looking forward to the next motion to dismiss so we can appeal. And so this just tells you how much of what's going on is not the crime on the ground or even the law on the book, but the judge behind the bench. And so we're very much looking forward to that appeal.
Some of us were wondering where we could find the materials you guys referred to.
They should be in your little gift bag, the USB.
On the app.
Oh, they're in the app?
Yeah.
Oh, how modern of you.
We've gone green.
There's a resources tab on the conference website on the left, and it has
There's a resources tab on the same app, the conference app that I asked you to update your attendees' information. So in that same place, you'll find all of the paperwork for each of the panels.
Thank you for that. That's a good question. And the answer is ethics. Whenever we had an officer-involved shooting when I was DA, I work with those cops every day. I see them at lunch, I see them in the gym. I mean, I know these guys. And if I don't know them on the street, I know they're supervisors, right? So I had a conflict of interest. When they do something bad or arguably bad, officer-involved shootings, conflict off. I would withdraw my office from the case, and I would give the case to another elected DA who had no interest in the case and didn't know these people, and that person would do the investigation, coordinate it with the state police, and then make a charging decision and decide how to handle the case after the fact. I think it is a per se ethical violation for a prosecutor's office to make an in-house decision about the conduct of law enforcement officers that they work within their own jurisdiction as a general rule. There might be exceptions to that, but as a general rule, that's where I always defaulted to. So that's probably the angle I would take. Now, I'm not saying go file a bar complaint. I'm saying sit down with the DA and ask him or her to articulate what the hell they're thinking and why they're not conflicting off and have them justify that.
Looks like we have time for about one more question.
This is a question for Gavin. Mic issue. That's okay. Your case resolved in August of 2012, is that right? The Bear case?
That's correct.
When did it start? How long was from start to finish was the whole process?
It started, I left the pleadings file in my car at the airport. It started in either January or February of 2012. It was fairly quick. 19A cases have to be brought in district court in North Carolina, so that is the lower of our two trial courts. So it's family law and minor matters and other things less than $10,000. This moved fairly quickly. That's one of the nice things about 19A.
It moved fairly quickly through court, but I will tell you, having been with ALDF earlier, we were working a lot on getting that evidence together. Before that, I was clerking the summer of 2010, and that's when we were looking for bear experts. And we were actually hoping to find some in North Carolina. We had to go international because, you know, bear experts, where are they? And speaking of the bear, did we get the video working? All right, well, it is on, okay, we'll get it running at the end of the lunch break, but it's Ben enjoying his freedom for the first time. And so it is time to adjourn to lunch, and I think the crowds will lead you that way, but it's out and to the left. Thank you.